Hi, everybody. Just going to give a few minutes for everybody to get logged in. We're going to get started in just a few minutes. Thank you, everybody, who's tuning in right now. Make sure everybody can see me and hear me. Thanks for joining. Hi. I'm going to just take a couple of minutes before we get started. I want everybody to get a chance to join in. Welcome everybody to DC Now and Small Biz Takeover with Sharp and Sound Style. That's me, Christina Calloway. And we're going to be talking about trademark basics for your business. Take a couple of minutes before we get. Hi, everyone. Thank you, Millie Only Millie, for your compliment and let me know that y'all can hear me. Hi, H. Balcom. Shout out to Nels, owner of DC Now Events. Thank you for the opportunity. Just take one more minute. Thank you, everyone, for joining in. For those who are joining in just now, I'm Christina of Sharp and Sound Style, trademark attorney in the DMV area. Hey, sis, Caramel 1913. Just a few more seconds. Thank you all for joining me this evening. This week feels kind of long for me, so I really appreciate you. We're going to get into dropping some gems and making sure you're getting the information you need for your businesses tonight, for your creative ideas. Make sure you're protected. Okay, we're going to go ahead and get started. Again, I just want to introduce myself. Christina Calloway of Sharp and Sound Style. We're partnering with DC Now Events for a Small Business Takeover. We're going to tonight be talking about trademark basics for your business. Hi, everybody. I'm glad you've joined. We're going to talk a little bit about trademarks, your businesses, your creative ideas, why it's important for you to protect your legacy through protecting your intellectual property. It's something that a lot of people don't consider when they're starting a business, even when they're a creator. Something that often gets left behind. It's a really, really, really important aspect of being a business owner or a creator, especially now with the internet, especially now during the pandemic. A lot of creative ideas. People are still starting businesses, and it's important, especially when you're doing business on the internet, that you're protecting yourself because it can be seen all over the country, all over the world. Hey, sis, Dr. Kelly Cavett. Okay, so let's get into it. And if you see me looking down, I'm just taking a look at my notes to make sure I'm giving you all the best information you need to trade for trademarks and about your businesses and protecting your legacy. So just want to begin and start with, what is intellectual property? When you're an attorney like myself, we usually say IP, or when you hear people say IP, a lot of people don't understand what intellectual property is. It's basically ideas or something intangible that you've created that you have rights to. People have ideas all the time. We're often told in law school that there are no original ideas, and that's why it's important for you to protect those ideas. Hi to everybody else joining in. I'm Christina Calloway of Sharp and Sound Style, partnering with DC Now Events about trademark basics for your business. So when we're talking about intellectual property, there are 3 types, but we're really going to be focused on trademarks tonight. But I really just want to give you an overview of the different types of intellectual property as applies to what we will be talking about. There are 4 types, but really most people are usually concerned with trademarks, copyrights, patents, and trade secrets. When we're talking about soft IP for creators and business owners, it's usually your patents, your copyrights, and your trademarks. So what are the differences between those 3? I'll just use a quick example. If you think about something like the Hoover vacuum, the vacuum is the actual invention, and that is what you would get a patent for. The jingle, the famous Hoover song jingle that is used in the commercial, is something that you might get a copyright for. And then the name Hoover, or the name or the brand of the company or that's on the product, is what you would get a trademark for. And that's what we're discussing tonight. When you're thinking about trademarks, you're thinking about the name of your business, the name of your brand, logos, any type of designs that you want to represent your company and that show or company or your ideas or your creativity that show that you are the source or provider of different types of goods, indoor services. So first, I always like to begin when I'm speaking with congratulating anyone who has started a business, that owns a business, who has any type of creative endeavor. That's not an easy thing to do, and you're inspiring. I always like to shout out people for even taking the chance to start a business, own a business, especially my young Black entrepreneurs. I love that. And so how does that apply to you when you're thinking about trademarks? If you're just logging on, we're going to be talking about trademark basics and the intellectual property that you need to protect for your business and your creativity. How does that apply to you? Why is that something that I need to protect? Why aren't you thinking about that when you first start your business or when you have a creative idea? A lot of people get hindered by the cost or thinking that they need an attorney to go about that process. And that's something that they can do later down on the road. I always tell people it's something that you should be thinking about immediately in your business plans. When you're creating anything that you're putting out into the public, that you should invest in your business and your creative ideas, just like you do when you have to buy a computer, when you have to buy a camera for your photography business, when you have to buy a building. Anything that you're purchasing, that's what you're investing into, and intellectual property should be a part of that. If you think about it, I was looking up today, I'll just ask this question and see if anybody knows. One of the richest celebrities that makes money still after their death through their intellectual property. Anybody know, or anybody can think of anybody that's still like at the top of the game and still making more money than living artists right now based upon their trademarks and the legacy of their intellectual property? Let me see if anybody knows. Hi to all those joining. We're talking about trademark basics for your business. So I just asked about if anybody knows who is making the most money. I'm getting a lot of Michael Jackson, getting a lot of Prince. It's Elvis Presley. I probably might have some people here that don't even know who Elvis Presley is. Hopefully you do. But it's Elvis Presley, and his family and the company that his family owns had the wherewithal, and they continue to protect his legacy through his intellectual property, his copyrights, and his trademarks. You cannot just put an Elvis Presley picture on a t-shirt and sell it. Trust me, their organization is going to come after you. That's how important it is. It lives after you. So when we're talking about why you need a trademark, this is something that's voluntary. You don't have to file or apply to get a trademark. You can do state trademark or something of that nature, but federal trademark is voluntary. You don't have to get it. So you have to start asking yourself, why would I want to pay the money, go through the application process to get a federal trademark? And I'll just do a slight plug here. I'm a trademark attorney at the United States Patent and Trademark Office, which is the office that is responsible for registering trademarks. It's in Alexandria, Virginia, if you're in the DMV area. And this is the office that is primarily only responsible for registering trademarks. And on the other side, they grant patents. And since we're just talking about trademarks tonight, I'm a trademark attorney there. Before we get into anything about the process, I just need to give a disclaimer that any information that you receive tonight does not create an attorney-client privilege or an attorney-client relationship, that I'm just providing you with any information. And if you have any specific questions, I'm happy to provide referrals. As a government employee with the United States Patent and Trademark Office, I cannot represent others, but I can definitely provide referrals for you from great attorneys that I know who are intellectual property attorneys that you can I'll give my contact information at the end of the session tonight. So it's voluntary. So what are the benefits of receiving a trademark? If you're just logging in, we're talking about trademark basics and why you should be getting a trademark for your business, for your goods and services that you're providing. One, you have the presumption of ownership. So I know you see things everywhere that have that little R with a circle. That means that it is a trademarked, it is a registered trademark. And that is a presumption of ownership that you're giving to the public. You're putting the public on notice that this particular brand name, this particular logo is registered. So I'm getting a few questions, and at the end, I'm going to actually pop up, but I'll take a note of your question unmatched to answer that. And it's something that I'm kind of talking about now, is that if you see that little circle with the R, that means that mark is trademarked, that is registered, federally trademarked. And if you see the little TM, that means that person has filed for a trademark. Their application has been sent to the office, but that they have not actually received a registration certificate that is not actually registered, but it is actually in the queue and they have applied for registration. Also, you have the ability to bring any actions in court. So if you have a particular name or brand or logo or design, then you would be able to bring in court any suit against someone for using that. Like I said, even though trademark is voluntary, you do have more of a leg up if you have to go to court, you have to file a cease and desist or something of that nature if your mark has been registered. That is something that you really, really want to think about. And a lot of people don't, and I always use the example for people that Apple was a small business. Facebook was a small business, right? Facebook was started in a dorm room. Apple was started in a garage. Even if you're thinking like, hey, I'm just a small business, I don't have the money, or I shouldn't be worried about this. You never know. I would assume as a business owner, as a creator, that you want that to improve, that you want that to move forward, that you want that to be really successful. And this is something that you should be thinking about, because others, I'm telling you, see what you're doing, and they always don't have your best interests. They see what you're doing and maybe that you're not purposely putting it out there the way that you should or protecting it the way that you should. And they seek to take it, to destroy it. And the biggest thing that you can do by that is stealing somebody's intellectual property. There are tons of cases where people have had to change the name of their businesses, of something of that nature, to change their, because someone has stolen their intellectual property. They may have had to change their name. They have to buy back their intellectual property for someone. So that's something that you definitely want to think about. And lastly, if you're selling any type of goods or services, you can also register your mark with the U.S. Customs and Borders Patrol. And so when people are bringing in counterfeit goods or something like that, there's going to be that point. There's going to be somebody at the border stopping them from bringing it in under your name. And if it is not exactly your goods and products, you can bring those claims against people who are doing that. Because trust me, if you have a good product, somebody more than likely is going to try to knock that thing off. And you don't want your good reputation to be on something that isn't properly in your name or in your trademark. So if you're just joining, again, we're talking about trademark basics for your business. We're going to get into the process. Again, I'll just say that there's a question box that I'm going to pop up at the end. You can drop questions into, and we can discuss some things that you specifically want to discuss regarding trademarks and protecting your intellectual property. So the process, how to apply. If I've decided, now you've decided, hey, I'm going to go ahead and go forward and invest in my company, invest in my creativity. I'm a content creator. I'm a photographer. I'm a hairstylist. I own a beauty salon, and I want to protect my name. I want to protect my logos, the things that I use to show people that I'm providing these particular services. Then you start the process for the application to file a trademark application. And that's at the United States Patent and Trademark Office. You can apply online. You would go to uspto.gov, and you can do that electronically or by paper. The office is trying to push people more to just apply by paper. So by online on a TEAS system, TEAS system. And the fees are different based upon whether you're applying online or whether you're applying on paper. So the fees per class as of now, because there's going to be a fee change that is going to change starting at the top of the year. As of now, if you were to file an application, TEAS Plus is $225. A TEAS reduced fee is $275, and a TEAS by paper application is $600. So now you see that there's a huge fee difference based upon how you apply in your application that you're applying for. So I'll explain a little bit more about those fee classes. TEAS Plus at the $225 fee level basically means that you're going to look at our ID manual that we have for you, and you're going to pick directly out of that what goods and services that you're providing. So again, say if you're a hairstylist and it's based simply hairstyling services, then you would just pick that out. You're allowing us to contact you by email only. You want to do everything electronically. That's the fee of $225. Hi to everybody joining on. And a TEAS reduced fee basically at $275 says, well, I have some kind of fluctuations on what I'm doing, or it's not specifically in the ID manual. So I'm going to tell you what I'm providing. I'm not going to take it directly out of the ID manual. I still want you to only communicate with me through email. So that's why we're charging the $275. It's just more processing, more things we have to look at because you're not directly taking it out of the ID manual. And again, the TEAS for the paper application is just $600. Because it's just more processing and things that you're submitting and have to go through the process instead of submitting electronically. And so once you pay your fees, determine the classes that you're putting all your goods and services in, you're submitting a drawing, which is basically what the name or company name or brand name or the logos or things like that you want to input. That's going to be submitted to the USPTO, where an attorney like myself is going to review the application and determine if you've met all types of statutory requirements, that there isn't another mark that's already registered that could cause a likely confusion. That's really the general reason why people are being refused for any type of trademark application, is that someone already has the mark. Believe someone asked previously in the chat about that. How do you know if somebody has your mark? So a lot of times I still tell people to hire an attorney, because you never know what issues you may run into. You do not have to hire an attorney to apply. You can be what we call pro se, so you can apply yourself. There's a lot of great information and resources at uspto.gov. Again, that's uspto.gov. There's like little videos that tell you about things, but you don't have to have an attorney to apply. Even if you run into some issues once you've applied, you can still hire an attorney if you feel like, I don't know how to answer this, or I don't know how to make these types of arguments, or whatever, what have you. But you can apply for a trademark yourself and get registered yourself. You don't necessarily have to hire an attorney. But the biggest issue that usually happens is that there's someone who already has a mark that has been registered, and there's a likelihood of confusion between that mark. Say, for instance, I can tell you now, if you have any mark that has the word Apple in it, Apple usually files what we call a letter of protest if you have any type of similar goods or services that they're providing. So let's go down and see here. So what does the USPTO do? We review the applications. Like I said, an attorney like me is going to review your applications. Hi to everybody joining on. I'm Christina of Sharp and Sound Style. I'm an attorney with the USPTO, which is the federal agency located in Alexandria, Virginia, that is responsible for registering trademarks. We register the trademarks, we review the applications, and what we do not do. So I want to go down through that. One of the biggest things that people don't understand about the USPTO, because attorneys work there, is that we are not your attorney. We're definitely not your attorney. So you have to understand that when you're working on an application, or I'm working with you on an application, I can walk you through things in the application. I can't give you advice of how to make an argument if you've received a refusal. I can't tell you if you have a good mark or something like that. If you have what we call a strong mark, I can only kind of guide you through what the application is and that process, but I can't tell you, hey, you're probably not going to get this, or this isn't a very strong mark, or anything of that nature. I won't be able to tell you, hey, if you got another name like this, you need to go ahead and get it trademarked. I'm telling you that now in a general sense. If you have anything in creative, a name of your brand, a name of your company, a name of any products that you're providing, that you need to get a trademark. That is important to creating your legacy and improving and being successful in your business. So another thing that the office does not do is that they do not enforce the rights. So like I talked about, once you get that registered trademark, you can send it to the U.S. Customs Borders Patrol if you have any type of goods that have a registered trademark, so that nobody can infringe upon what you have. And that's something that you want to think about. But the office is not going to file any cease and desist letters on your behalf or anything like that. That's up to you to maintain and enforce the rights that your registered trademark has. We just have it on file that this is a registered trademark, but we're not going to enforce those rights for you. We don't conduct trademark searches. That is something that you can do on the website, uspto.gov. So that's how you can find out if anyone else already has a registered mark that is similar to yours. So say if I was looking up something, if I had a law firm and it was Callaway Law Firm, and I looked it up and someone had the exact same name or a similar name for the same service, legal services, I'm probably not going to get that mark because there is a likelihood of confusion that people may think it is my services are under the other person's name or of that person's services. So I'm technically using their reputation. Another thing is that we don't comment on the validity of marks. Again, like I said, I wouldn't be telling you at the office that, hey, this isn't a very strong mark. Like, you came in here for batteries for batteries. I can't tell you that you're probably not going to get that mark. That's not something that we comment on. I'm just going to do the search, determine and provide any refusals based upon that, explaining to you why this isn't this application may not go through. And we also don't police infringers. So again, like I said, we won't be filing cease and desist letters. We won't be letting others know that they shouldn't be using your mark. That is something that you have to do. So basically, again, the USPTO is not your attorney. If you run into any issues, you should definitely hire an attorney. There are great resources of how you can do that. I like to always tell people, because they don't know, that you can, if you're an artist, if you're a creator, they have like Washington Lawyers for the Arts. If you're meeting their criteria for the certain amount of money that you make, you can definitely apply for those services to see if you can receive basically pro bono services as a creator. That's something that you want to look into. But I also tell people, when you're thinking about the pricing, is that you should also think about how this is an investment for your business. So you never know, you talking to your CPA or how you do your taxes, that this is something that you can write off, because it is a business expense that you're providing or that you're receiving, because you're filing a trademark for your business or for your creative ideas. And I'm just looking to make sure I'm hitting some of the questions. I can see them as I'm talking, and that's why I'm trying to hit some of the things. I'm getting some general questions about retainers. And I'll briefly talk about what happens after you get the registered trademark. So you've applied, everything is going well. You've now received this shiny new certificate that says your mark is registered. So what does that mean? What do you do with that? How do you let the public know? Again, you're going to be able to use that R with a circle. That means you are legit, that this mark is registered and no one can steal it. And if they attempt to, that you are filing a cease and desist. You also have to maintain your registration with the USPTO. I won't go into how that goes, but the office will send you notices of renewal where they're reminding you that it's your time for renewal is coming up, and there are fees associated with that. But as long as you renew those, you can keep your trademarks in perpetuity, which means forever. So even after you die, as long as your company or anything or your family, that is something that is tangible. Intellectual property holds a lot of weight as far as money. You see people fighting for it all the time. You see Kanye talking about his masters and things like that. Those things hold a lot of weight, hold a lot of money, and that's something that you can keep moving forward and doing. So if you don't maintain your registration with the office, it'll get canceled. You'll have to go through the process all over again. So just think about a company like McDonald's that's been around since the 50s. They've had their registrations forever. They have had to maintain that since the 50s. And if they don't, and it was canceled, then somebody could technically take the name McDonald's. So that's something that you want to think about, that you have to continuously go through and keep those things. Keep your trademark maintained through the office. And you also can enforce your rights after you maintain, like I said, after you've received your registration, you can maintain the rights that you have, and filing cease and desist letters, keeping up with those particular things. Some people put Google alerts so that they can see when people are using their mark. But anything that you need to do to maintain and enforce those rights, you now have a piece of paper, a federally registered trademark that says you cannot use this for the same goods and services. And when I'm talking about a likelihood of confusion, it has to be for the same or similar goods and services. So if somebody has a name of your product for something that's completely different for legal services, and you're selling candles, they can probably have the same mark, because somebody is not going to go into the marketplace and believe that these two things are related. That's something that attorneys look at when we're looking at likelihood of confusion. We're looking at the goods or services and thinking, can we find evidence that somebody might look at this particular thing and these particular services and believe that they are under the same source? So when you're looking at, a lot of times we're looking at clothing. Somebody can come in the same name for tennis shoes or sneakers, and somebody comes in for t-shirts. There's a likelihood of confusion because t-shirts and sneakers are sold under the same, can be sold under the same name, and people might think that they come from the same location. So again, to everybody joining in, I'm Christina Calloway, Sharpen That Sound Style. I am a USPTO trademark attorney at the USPTO, which registers, federally registers trademarks. It's located in Alexandria, Virginia. Although you wouldn't go there in person, wouldn't go there in person now, where you could file your trademark applications online. And I'm just going to briefly go over copyrights, even though I don't practice copyrights at the USPTO. I do know I'm an intellectual property attorney. I do know about copyright. So I just want to talk about those, because when we're thinking about Instagram and all the social media, a lot of people are doing business or creating on these platforms. So copyright is something that you really, really want to think about. So do you need a copyright? Again, any type of copyright registration is voluntary, just like trademarks. So again, you're asking yourself, why do I need to pay for a copyright if it's voluntary? Again, you can bring those lawsuits. If somebody is using anything for your copyright, it's public record, public knowledge, and putting people on notice that this is registered. And you can file for any type of statutory damages in court. You know, there's what is called copyright infringement, and that's what you would go to court about if someone is infringing your copyright. So again, just to let you know what a copyright is, we talked about trademarks. And trademarks is any type of brand name, logo, design that you're showing that this is providing these products or services under this particular name. A copyright is anything tangible that you're creating in a fixed, intangible that you're creating in a fixed medium. So what does that mean? Basically, if you're writing a song, you have a copyright in that song the moment that you write it on a paper, even if nobody has ever heard it, because you've thought of something intangible, right? A song in your head, and you put it down in tangible form in a fixed medium, which is the paper, or you've recorded it, even if nobody's ever heard it. But again, the issue with that is, say if you lose that, say if somebody steals it, say if somebody hears it and then they go register for it, then they have that copyright. It's best that you federally register that copyright. A lot of people ask about poor man's copyright. There's no such thing. Poor man's copyright is what people think is when you write something down and you mail it to yourself and you have a date of when you created something. That is not going to fly in court. You need to have a federally registered copyright when you're thinking about copyright. So copyrights, if you're in the realm of a content creator, a digital content creator, if you're an influencer, if you're a photographer, if you're a songwriter, if you're an artist, if you're an actor, those types of things where we're thinking particularly about artistry is when we're looking into trademarks. But even artists, say you're thinking about your Beyoncé's and Bruno Mars. These are some people I know that have trademarks of their name. Jay-Z have trademarks of their names because they are providing a particular service. A lot of people even attempt to trademark their children's celebrities attempt to trademark their children's names because they don't want people using those names to sell any type of products and services. Why? Because they don't want their reputation associated with that is their kid. They don't want somebody trying to sell something under that particular product or name. Let me just make sure I've hit everything. And again, for both, I just want to let everybody know, again, the websites, you can go to uspto.gov for trademarks. And for copyrights, you can go to copyright.gov and uspto.gov. And I have some questions here. We're going to pop some up. And please feel free to drop your questions in the little question box below. It's on the bottom near the comment box. One, it's easier for me to see. I don't have my glasses on. And so that everybody can see the question as well. Are the renewal fees comparable to the initial application fee? They're not. That is a great question. The renewal fees are usually around $100. So they are not. And you're doing that over a period of time. So I won't go into depth about it, but as far as renewal, you go from for trademarks, it's every 5 to 6 years. The first 5 to 6 years is when you will be renewing it for the first time, and then into 10 years, and then 10 years after. So it's a period of time that you're going, and it's usually like $100. That's if the fees don't change, but as of right now, it's $100. Hope that answered your question. But you see, it's something I think up front when people are thinking about the money for an application, they're thinking, oh, that's a lot of money on my small business. I don't have money for that. But over a period of time, I mean, $225 up front, I know can be a burden or hardship when you're a small business or you're just starting out. But over time, you're not spending that much and you're gaining so much from your intellectual property rights. So you want to protect that, because especially if it becomes your business is going to be very successful, your creativity or your creative ideas become very, very big. You don't want someone else to be able to profit off of that. Do I know the copyright fees? So yes, copyright fees for one work or made for hire work where you are the only author. There are different levels, but I'll tell you like the basic one, which is when it's for one work, like if you've written a song just by yourself and you're the only author, it's $45. And paper forms, again, they're pushing you to file electronically, are $125. Now, there are different levels based upon the number of authors and things like that. But if you're the only author, it's a work for hire, it's electronically one work, then it's just $45. So I talked a little bit about this. What's the difference between a trademark, a copyright, and the patent? A trademark is any brand name, any logo, any design that you're using as the name for your business. A copyright is anything that you make, an intangible idea that you, an intangible work that you write down or create in a fixed medium. So if you're writing a song, writing poetry, writing a book, as soon as you write it down in a fixed medium or you're typing it on a computer, that is a copyright. It just hasn't been registered, but that is a copyright. And patents are for inventions only. Trade secrets don't really talk about a lot, but trade secrets are like a recipe, a process that you don't want to be known. So if you're thinking about trade secrets, think about like the Coca-Cola recipe, right? Nobody knows the Krispy Kreme recipe or the Coca-Cola recipe. That would be a trade secret that you can protect. So how long does it take for a trademark to be registered? That's a really, really great question, and one I can't give a concrete answer to. So right now, of course, we're in the middle of a pandemic. So processing times are around about 2 months for an attorney to see your application. But I will tell you this, once you file your application, we call that priority filing or first to file. So say someone has a similar name for similar services or goods, but they filed after you. Even though you haven't had the haven't received the registration, you are first in line to get that registration if your application goes through with without any issues. So say, for instance, someone comes behind you in the application, it could be a day later and they filed it and it's the same. They're going to receive a letter from the office that says, there's somebody ahead of you. If this files or if this registers, there's going to be a likelihood of confusion. So there's a likelihood that you will not get this particular mark. So you still have a little bit of protection, even though you filed. You still have a little bit of protection because you're the first to file. The live will be available. I've got a question about that. The live will be available on DC Now events page after the live tonight. And I think I had a couple more questions. So can someone challenge your trademark after it has been approved or it is protected? Good. That's a really, really great question. They can challenge your trademark. So after the trademark, so what happens when you file for a trademark? Say you come in, which is what is basically called an intent to use. You're not using your mark yet in commerce. You just want to get it protected. And what we call a 1B application, we would approve it or say it's going to go forward, but you're going to have to eventually show us that you're using it in commerce, because you can only receive a trademark if you're actually using it in commerce. A great example of that people may know is like Blue Ivy, the daughter of Jay-Z and Beyonce. They're actually in a lawsuit with a company called Blue Ivy for event planning services and different type of services. And they're trying to get that trademark canceled because they want to protect their daughter's name from anybody having any goods and services under the name. But remember, you have to be using that mark in commerce. So the company Blue Ivy has an argument, or continually has an argument, that they are not using this mark for any goods and services. Well, if you know anything about Blue Ivy already, she's having books and things like that. But as of now, they're in a fight for that name because she technically isn't selling any goods or providing any services. So your trademark, after it has been approved, before you're showing us a use, someone can send what they call a letter of protest to say, I oppose this particular mark for these reasons, and they provide evidence and arguments. I also explained about Apple. If you have anything with the name Apple for computer, anything that's related to their goods, you're more than likely going to receive a letter of protest from Apple saying we oppose this particular mark. So what are the fees and costs for the processes? Again, I'll go through it really briefly. You can find more information about what the fees are and the differences between the fees at uspto.gov. So for a trademark application, you have T's Plus, which is $225. That's when you're filing and you're going to use our ID manual to directly pull out the goods and services that you are providing. And that you're saying you're going to allow us to communicate with you electronically only. Then we have what is called T's reduced fee. And when I'm saying T's, it's TEAS. T's reduced fee at $275. That's where you're saying I'm allowing you to contact me only electronically, but I don't want to directly pull out the goods and services from the ID manual. I'm going to tell you my own. And so we just charge the processing fee for that. And then for a paper application, it's $600. Let me just make sure. Any questions here? Great question. Can a hairstylist trademark or copyright their name or service? So just again, to distinguish trademark and copyrights, Copyrights are for artistic works. They're only for artistic works. So when you're speaking or talking about, when you get your trademark, don't call it a copyright. It's called a trademark. Trademarks are for brand names, logos, designs that you show that you're providing, that you're using to say you're providing a good or a service. So yes, a hairstylist can trademark their name. They can trademark their services. So if you have a particular name, let me think of a famous hairstylist, Paul Mitchell. Paul Mitchell has trademarks for his name and his academies, and I don't know if he's living or not, but their names and academies and the services that are provided at the hair salon. So yes, a hairstylist can trademark their name and their services, or the business that you have, or the name that you have for your business if it isn't directly your name. So you can trademark a name. And I think that's all the questions that I have in the box. I'm just going to check my notes to make sure that I have told you everything I need to. If anybody has any questions, again, I'm Christina Calloway of Sharp and Sound Style. I'm a content creator as well. I'm an attorney. I'm a content creator in Alexandria, Virginia, where I focus on local lifestyle, style, fashion, and local living. If you want to follow along, I always love in these particular types of sessions. Drop your businesses, drop your ads. I love to follow people, see the creativity. People are doing so much during the pandemic. People are on their phones a lot during the pandemic. This is a great time for you to really build your brand, for you to really pivot. What the word of the year is pivot. Come up with ideas about how to get your ideas in different types of branding out into the world. Yeah, so like I explained before, if you just joined, I work for the federal government. So although I am an attorney, I cannot represent anyone that's coming into or wants to file a trademark with the office, because your trademark may come before me, and that would be a conflict of interest. So definitely I'm going to provide you with my information now, but just keep in mind that it has to be in a general sense. I can't tell you specifically something about your mark. But I can definitely provide you with more information. And if you wanted to move forward and you wanted to hire an attorney, I definitely have great referrals to you. I went to Howard Law. Howard is about to be lit, I'm telling y'all, since Kamala's in the office. If you thought we got on your nerves before, it's going to be worse. But I have a great network of attorneys that I can provide for you as far as IP. So if you have any questions about the live tonight, anything like that, please feel free to give me please feel free to send me an email at christinacalloway@aol.com. That's CHRISTINA, Calloway with an O, CALLOWAY at AOL.com. You can also find me at sharpandsound.com. That's sharp, the word sharp, the word and, the word sound.com. And you can also contact me there, and I'll get your emails and questions there as well. Let me just make sure don't have any other questions in my question box here. I'm sorry. Y'all still hear me? Yeah, thank you for putting that in. Again, sharpandsound.com. And if we have any more questions, like I said, drop your ads, drop your businesses. There are people in the chat, so they may see that. Just a short, drop your ads so people can go and see what type of services you're providing. Any type of collaboration if you're a content creator. This is also really, really, really great way to connect, even though we're doing this virtually. Like I said, I want to congratulate everybody who has any type of business, who's creating during this time. We're all getting adjusted and still trying to figure it out. So if you're thriving and coming up with new ideas and people are responding to it, kudos to you, definitely. Yep, I'll pin my information. And I'm sorry, y'all. This little writing. And there's a contact there's a contact form on my website. And again, I just want to shout out DC Now events. Thank you so much for the opportunity. I love sharing this type of information because I find that so many people don't know. Even though the website is there, it can be very confusing, not at all user friendly, and people need to know this information, especially I know that everybody in the chat might not be African American or a Black person, but it's definitely important for minority creators, for women, to know about this type of information. I can tell you all types of movies and things where you can see how this can easily happen. I always bring up the McDonald's movie. People don't know that McDonald's, the person that we know as the owner of McDonald's, that isn't his name. He took that from someone else. That's intellectual property. So it's very important. People see the value in that. And so you need to see the value even before you have blown into this stratospheric success. And again, I want to shout out DC Now events. Thank you. Thank you, Nels. I don't know if you want to drop anything that you want me to say before we end for the evening, but definitely let me know. Yep, Ray Kroc. People know about that. It's a great the Black Math Academy. Yep, Ray Kroc, good film to study. It's really interesting, and it's really all about intellectual property. Joy is a good one with Jennifer Lawrence. It's about people stealing her patents. Really, really great. And if I don't have any other questions, let me just make sure. Before we finish for the evening. Yeah, if you want to drop your ads, I'll just shout out to some people. Not endorsements, but just shouting out. Real Rolicious conducts online Zumba classes, especially for families in need, which is great. So many people are working out at home. People need to be active. They got the kids at home. They need to be active. It's getting cold. We got to go back inside. That's really great. I know I got Caramel 1913, has a photography business in the Tennessee area. And make sure you're following DC Now events and following. They always have in the know about what's going on in the area, about things you can do. They host the Small Biz Takeovers this year that have on this virtual platform so that you can get any information. They've had all kind of sessions, even ones that I've attended since I'm starting in content creation that you want to know about and tips and things that you need. And it's accessible. It's free. You're getting this information. Yeah, the Black Math Academy. Shouting you out. And I'll make sure to follow. And I'm just checking to make sure I don't have any other questions. Again, I'm Christina Calloway, Sharp and Sound Style. We were talking about trademark basics for your business and the importance of protecting your legacy through intellectual property. Nels, anything you want me to say before I log off for the evening? Or anything else I need to discuss? All right. If we don't have any other questions, I look forward to connecting with you, whether that's on IG or if you have any specific questions that you want to email me about, talk to me about. Again, like I said, I'm happy to discuss anything with you in a general sense. So just pose it to me in a hypothetical way. And if there's something that you feel like you need an attorney for, I'm happy to refer you to attorneys. Please be reminded, I know a lot of people are doing virtual meetings and things like that. Since this is federal law, you can hire an attorney anywhere. So you can hire an attorney in New York. You can hire an attorney in Georgia. I'm licensed to practice law in Georgia, but I work in DC or Alexandria. So this is federal law, so you can hire an attorney from anywhere. And I also know attorneys in all different places. So wherever you are, if you're not in the DC area, I can definitely get you a referral if you want somebody that lives in your area or in your city. Or if you don't mind, I can definitely get you a referral. All right. Thank you all for joining me. I hope you got a lot of great information. I hope you are definitely thinking about protecting your legacy through intellectual property and making sure that you're protecting that, going through the processes, considering that a business expense, an investment in your business so that you can have that for years to come, so your family can enjoy the fruits of all those great ideas and your great businesses in the future and beyond. Good night, everybody.